Thank you for joining us today as we learn more about beneficiary deeds. Beneficiary deeds. Here's what a beneficiary deed looks like.
If you are a single owner, make sure to use I instead of we. If there are multiple owners, make sure both are listed and that you use the correct pronoun. Make sure the correct county is listed in the notary block. You will need to select whether the client wants the beneficiary's interest to become void or pass on through the beneficiary's estate should the beneficiary predecease the owner. If you list multiple beneficiaries, you need to select whether they will inherit as joint tenants with right of survivorship or as tenants in common. Clerk and Recorders requires 1/2 inch margin with a 3-inch margin at the top. The beneficiary deed allows real property to be transferred to a beneficiary without going through the probate process. There is no limit to the value of property you can transfer via a beneficiary deed, nor is there a limit to how many parcels can be transferred. Pros and cons. Pros: it's easy, quick, and there is no probate necessary. Cons: it's easy to forget about, and the property is still subject to creditors' claims and liens. It does not protect from Medicaid collection. It is important to remember that creditors get a full year to file a claim on the property before it can be sold by the beneficiary. For reference, check Montana Codes annotated 72-6-123 and 72-6-228. The warranty deed, last vesting deed, quit claim, special warranty, or grant deed is needed for the legal description of the property. It must be copied down verbatim in its entirety. Note, if the last vesting deed's legal description has changed, for example, new certificate of survey or the owner sold a piece of the land, then the deed's legal description will not be valid. Your beneficiary should get a copy of the beneficiary deed. If multiple beneficiaries are listed, make sure you explain the difference between A, joint tenants with right of survivorship, and B, tenants in common. A, basically this means last man standing. If one beneficiary dies, the remaining beneficiary will inherit the entirety of the deceased beneficiary's share in the property. B, property remains a part of each beneficiary's estate, even if they predecease the other beneficiary. You need to discuss the possibility of beneficiary predeceasing the principal. Do you want the property to then transfer to the beneficiary's family, or would you like the deed to become void? The senior will pay per sheet to file, so try to limit document length.
Thank you for your time today. Please be sure to call us at 406-444-7787 if you have any questions, or visit the link on the screen for more information.